Maybe let me begin, I guess, first by introducing myself. My name's Jessica Clogg. I'm currently the Executive Director and Senior Counsel at West Coast Environmental Law. I'm a white-bodied settler. I grew up in the Lower Fraser Valley out on the east side of Stave Lake. Anyone's from out that way, out in McConnell Creek. If you're not familiar with it, as you head out Highway 7, it's sort of north of Dewdney up the valley away. And I understand that I was invited to speak today in part because of the occasion of West Coast Environmental Law's 50th anniversary this year as one of Canada's leading public interest nonprofit environmental law organizations. I think the idea was that offers a bit of a unique vantage point on the history of BC forest policy and in the sort of history of our evolution. Just checking, sounds okay? Pretty good? All righty. And let me just, I don't have very many slides, but I'll just bring this up for a sec, just so you, let's just see if that works. And just do that. So I had entitled this talk, Reflections on 50+ years of BC forest policy, a sort of a personal and organizational journey. So we're going to go on a little bit of a ride here. As people were doing their introductions, I loved it. I was like, wow, I'm amongst friends here. And so I'm going to get a bit nerdy on the forest stuff here. So I just wanted to throw up, before we got into the heart of this, well, here, I'll leave this up for a little bit while we chat. So I first joined West Coast Environmental Law almost 30 years ago in 1995 as a summer student. And I served as our forestry lawyer beginning in the late 90s until taking over as executive director and senior counsel, though, of course, forest policy is still close to my heart. And in this way, my own sort of personal and professional history with West Coast are sort of interwoven into my understanding of the history of forest policy. So that's the little journey I'm taking you on today. So West Coast Environmental Law first opened our doors in the summer of 1974. And so 50 years ago, a dedicated group of law students, shown here in the Vancouver Province article of the day, came together to kick off an innovative summer project. They aimed to provide legal information and advice to residents concerned about environmental problems. There were 6 students from UBC and UQAM, University of Montreal, and they were the young legal minds behind what later became West Coast Environmental Law. So initially known as the BC Environmental Law Center, this hub the students created was originally envisioned as a temporary project for students over that summer of 1974, but it quickly became clear that there was an ongoing need for legal services, free legal services in support of the environment and community health in British Columbia. So the humble student-led law clinic eventually grew into what are today the 3 sister organizations that make up West Coast Environmental Law. We've never used the term eco-guerrilla since. I think that's a case of inflammatory headlines. And who knows who came up with that originally, but haven't used it since. So that grew into 3 sister organizations. We have a charity, the Research Foundation, the West Coast Environmental Law Association, and also the West Coast Environmental Dispute Resolution Fund Society, which through which we, through a network of lawyers all around the province, support local communities in accessing environmental legal aid services. So into the history part. It is interesting to think that when West Coast first opened our doors, the first legislation regulating forest practices in British Columbia, as you know, the Forest Practices Code of British Columbia Act, was still 20 years off. And it was less than 20 years in the past since the Royal Commission on the Forest Resources of British Columbia, headed up by the Honorable Gordon Sloan, Chief Justice of British Columbia, which was struck in 1955. I'm just going to take this off because I don't have a lot of slides about this. I thought about putting up a shot of, like, you know, Chief Justice Sloan, but, you know, you can look that up online. So when we opened our doors in 74, Forest Practices Code is still 20 years off, and it's been less than 20 years since the Sloan Commission. Now, that's not to say that there were not laws about resource extraction in BC at that time. Indeed, the colonial history of British Columbia is very closely intertwined with laws designed to facilitate the exploitation of mineral, forest, and other resources through the granting of various forms of resource rights, or what we often refer to as tenures. So it was really any form of environmental regulation of forestry that was years in the future when we opened our doors. BC's first Forest Act, for example, as many of you will know, was legislated in 1912. So for those first West Coast legal volunteers, from a forestry perspective, the era in which they began legal practice was still in large part shaped by those policy decisions in the mid-20th century, informed by the two Sloan Royal Commissions in 1945 and 1957, and incorporated into the Forest Act, largely in 1947. And I appreciate the fact I'm with like fellow lovers of forest history, because you might be amongst the small cadre of people who are interested in this history. So, you know, when we look at those early Forest Act changes that incorporated many of the recommendations of the Sloan Royal Commission report, there were two sort of key tools to facilitate sustained yield management that were introduced at that time. First, there were long-term secure area-based tenures to be granted to large private companies. They were called forest management licenses at that time, and later tree farm licenses. And then secondly, areas of Crown land were identified as public working circles. Those were, of course, the predecessors of today's timber supply areas, to be managed by the province, in which volume-based licenses were to be granted. So that mid-20th century architecture of BC's forest tenure system, in my humble view, remains a dominant factor in understanding forest management in BC through the years and today. In fact, because those key elements are largely intact today through different, ebbs and flows of forest policy and forestry law. Those aspects remain largely constant. Someone was talking about terminology. I don't want to assume anything. Let me just start by saying a word about what I mean, or what's meant by forest tenure. Some of you are very familiar with this. Tenure is essentially the forms of licenses and leases through which private parties gain access to manage and harvest on so-called Crown land. These are typically referred to as resource tenures. Internationally, it's more common to see the term concession, but it's largely used in a similar way. Now, this is going way back in time, but in BC and in Canada, the use of the word tenure is actually an allusion to quite an archaic tenurial system of land holding in Britain, whereby a subject had to render certain services to the Crown in order to have the right to work and occupy the land. So in our general thinking about private property today, the concept that access to land also involves societal responsibilities has largely disappeared from our systems of property ownership, but the notion survived in the early development of the forest tenure system in BC. What used to be referred to as the social contract, whereby licensees used to have obligations to operate processing facilities, for example, as a condition of tenure access. So when the tenure system was introduced in the 1940s and continuing on to this day, it was in theory designed to insulate forest-based communities from the boom and bust cycles of the forest sector, as I mentioned, by introducing sustained yield forestry and by encouraging investment by large integrated companies, i.e. companies controlling many phases of production, manufacturing, and sales, as well as logging itself. Now, in 1957, the Royal Commissioner, Gordon Sloan, assured the BC government that by providing an assured continuity of supply of raw material to timber companies, this would encourage them to engage in the construction, maintenance, and uninterrupted operation of costly integrated conversion plants, mills. And he said this in turn should result in a maximum continuity of employment in all phases of the industry, from logging to transportation and conversion into the end product. Now, sadly, the forest tenure system was actually quite successful in giving away forest rights and attracting large integrated timber companies and in encouraging them to build mills. But sadly, this analysis failed to take into account that fluctuations in demand for wood products, the prices of lumber, over which BC has very little control, were to have impacts on the economic prospects of the BC forest sector that could never be fully addressed by access to raw materials to the forest through the tenure system. And the tenure system, despite these assurances, did not prevent periodic downturns in the forest economy. And while companies often bounced back, regularly jobs failed to do so. The tenure system was essentially based on a neat philosophical framework that sustained yield ensures community stability. However, Sloan did not hide the implications of this in fine print. From the beginning, it was clear that in implementing so-called sustained yield management in BC would mean converting BC's first growth forests into normal forests to be harvested on periodic, predictable rotations. In other words, sustainable yields were calculated based on the growth rate of immature stands and this is a quote from Sloan, the orderly liquidation of the timber beyond rotation age. In other words, the system was based on the premise that we would be replacing BC's first growth forest by managed timber crops. In addition, the BC tenure system and the sustained yield policy underlying it encouraged the development of mill capacities. And this is again a quote, were designed for the massive and rapid clear cutting of first growth forests. However, and I think this is, I'm sure no surprise to anyone on this call, the sustained yield theory never promised continuity between this conversion period in which we were liquidating our remaining old growth forests and subsequent rotations. And of course, now we've seen for many years uncertainties created by the juxtaposition of mill overcapacity in relation to wood supply. This is often called the fall down effect. There was no sugarcoating it back in the 40s. The writing's been on the wall for decades that when first growth forests are depleted and cut levels must be reduced to reflect the actual volume and quality of wood available from primarily second growth forests, we have this fall down effect. The tenure system also had unique implications for Indigenous peoples, for First Nations, inherent title holders. The tenure system that was implemented from the 40s and through the decades paved the way for a massive allocation of forest lands to non-Indigenous parties. Most forestry activities over the decades in BC occurred on First Nations territories without their input or consent and with little economic benefit. Indeed, at the time that the BC forest tenure system was being shaped and developed, it was still illegal for Indigenous peoples to hire a lawyer to assert their land rights. That was illegal until 1951. So, returning to our young law students in 1974, this system presented a number of challenges. So while laws were in place to grant timber harvesting rights, and these have been granted to more than 80% of the province in what was in provincial forests. There were few legal tools available to address the impacts of logging and the forest industry on water, habitat, health, air quality, Indigenous rights, etc. So looking back at our files from our early days, I was in the paper records today, West Coast lawyers took aim at these issues creatively, drawing on fish habitat protections in the Federal Fisheries Act to tackle dumping of logging waste in streams, challenging permits for fish harming herbicide use by the forest industry on behalf of the United Fishermen and Allied Workers Union, now part of Unifor, but back in the day. Challenging pulp mill pollution on behalf of small local groups like Shave Our Shores Prince Rupert, including a PCB spill by Columbia Cellulose, and noise and air pollution from sawmills in the Kootenays. And those early days also set West Coast environmental law on a course, not just to enforce existing environmental laws, which were few and far between at that time, but to actually reshape or have the goal of reshaping the legal landscape to better care for people and the planet. So not a short journey, and one that is ongoing to this day. One of the interesting things to me is that looking at the legislation that West Coast first worked on, which I think is, as today, both a combination of need and impact, but also the political opportunities that present themselves. And in our early days, a lot of West Coast work was really around securing sort of bedrock environmental legislation, the creation of the BC Environmental Appeal Board, the Environmental Management Act in 1981, and subsequent campaigns to secure some of the strongest regulations in the world to address contaminated sites and pulp mill pollution under that act. We also were very actively involved in shaping and advocating for the Canadian Environmental Protection Act and the Canadian Environmental Assessment Act. I'm going to come to in a minute sort of the history of why those pieces of legislation or the areas we were able to have impact were not as directly, didn't take on quite as directly the day-to-day operations of the resource sectors in BC. But one of the early chances West Coast took to attempt to influence the forest tenure system and BC forest policy came with the appointment of another Royal Commission headed up by Peter H. Pierce. And the report of the Royal Commission on Forest Resources was published in 1976. So whilst some changes occurred around the margins following the Pierce Royal Commission report, the resulting amendments to the Forest Act retained the basic structure of the timber tenure system, leaving it largely intact. So area-based tree farm licenses were maintained as a primary form of tenure, and a new volume-based tenure, the forest license, was created for granting rights to harvest timber in timber supply areas. But functionally, the system remained largely consistent. And indeed, today, more than 70% of BC's allowable annual cut is still held by companies through one of these forms of tenure, the forest license or the tree farm license. Now, while much was made in the 1980s and 90s, some of you are old enough to remember that, I certainly do, about there being newly emerging environmental values and new public concern with the impacts of logging. That isn't necessarily the story told by submissions to the Pierce Commission in 1975 and 76. Alongside lawyers from West Coast Environmental Law who made submissions and appeared before the commission, there was a long list of community and environmental groups from around the province, as well as fishing, hunting, trapping, and guide outfitting associations who made submissions. And I made a list. I was going to put them up on a slide, but there was more than 20 of them. We had the Alpine Club of Canada, we had the Okanagan and Snoqualmie Parks Society, the Outdoor Recreation Society, Sierra Club, Society for Protecting Spec Society, Promoting Environmental Conservation, Steelhead Society. Their voices were not absent But what is noteworthy is that the commissioner dismissed environmental concerns about clear-cut logging in a scant 5 pages of a 500-page 2-volume report, finding that professional testimony put to the commission supported the conclusion that clear-cutting was the most suitable technique for both silviculture and environmental reasons in most of BC's forests. On page 281. Okay. So it would be fair to say that in the 70s and for many, many years on either side, the power of the forest industry and the importance of the forest sector to BC's economy left little political space for progressive law reform or for the voices of local communities impacted by unsustainable logging to be heard. The tide began to shift in the 1980s as community groups began increasingly to turn to direct action in watershed by watershed conflicts over clear-cut logging, and with the recognition of existing Aboriginal and treaty rights in the 1982 Constitution. A quote that I have always found forward-looking. It comes from Mr. Justice Seaton in the Mears Island court case in 1984, granting one of the only injunctions to the Taloquayat to prevent logging in this area of Clayoquot Sound. And he said, a decision favorable to the Indians, and this was about Aboriginal title, will cast doubt on the tenure that is the basis for the huge investment that has been and is being made. There is a problem about tenure that has not been attended to in the past. We are being asked to ignore the problem as others have ignored it, and I'm not willing to do that. So a change in administration, as we know, paved the way for significant shifts in forest planning and practices. Beginning in the early 90s, we saw large-scale multi-stakeholder strategic land use planning process, the old Commission on Resources and the Environment, later Land and Resource Management Plans, or LRMPs. And those tables were tasked with negotiating new protected areas and to set high-level direction for biodiversity and other values. Finally, here we go, we're 20 years later, we've got the new Forest Practices Code, which for the first time established baseline protections, for things like streams and other values, and introduced a new system for operational forest planning. So from the West Coast environmental law perspective, in the 1990s, many of the environmental legal aid grants made by the West Coast Environmental Dispute Resolution Fund were to environmental and conservation groups to obtain legal and expert advice to enable them to participate in these core and LRMP land use planning processes in many regions of the province. So the consensus approach of those tables, along with this environmental legal aid, did help even the playing field for community and environmental voices in those planning processes. And so since this is just about the time I joined West Coast Environmental Law, I want to just take a moment to return and weave in a bit of my own personal history here. And some parts of that were the experience of growing up in a logging town in the 1970s, where most adult men worked in the local mill. There were few jobs for women in the industry at that time. Indeed, you could drop out of high school at 16 and make a good wage in the mill. And it was often said, although I'm actually not sure if truthfully or not, that about 75% of all the shakes and shingles in North America came from Mission, BC, which is my hometown. And I note in passing that is an industry that requires tight-grained, old-growth wood for a quality product that's very, very hard to come by these days. So I lived on a small Harvey farm out on the east side of Stave Lake with a water license on a local creek for drinking water, and in a valley surrounded by progressive clear cuts. One of the results was catastrophic flooding. Not just once, but every few years. Wash houses away, blow out your water line, water covering the roads and fields. You could swim in your basement, flooding. And yet, growing up, it felt really as if me and my neighbors had no control over land use decision making that was affecting us. And as I was to learn as time went on, that was indeed because decisions, strategic decisions about logging were being driven by decisions made in the boardrooms of logging companies nowhere nearby. And so that desire to understand why that was and how that situation could be changed eventually led me to do a joint master's in environmental studies and law and to my work at West Coast. And initially, when I started my graduate work, I had thought that I would focus on the process and outcomes of multi-stakeholder land use planning processes. I was really excited. I'd done environmental negotiation and I was excited by the consensus-based process. And I thought I wanted to write about the impact of those processes on better forest stewardship in BC. But my research kept bringing me back to two critical unresolved issues. One was the ongoing outsized influence of timber companies, that did not disappear at the planning table. Rather, because tenure reform was not on the table, companies' long-term management and harvesting rights through the tenure system were taken as a given, with all measures, whether that's planning or regulatory for the environment, were seen really as so much red tape constraining those rights held by the timber companies. So at the end of the day, no consensus outcome was possible without their consent. And the status quo was tipped heavily in their favor. So if you ever taken a negotiation course, they talk about what's your best alternative to a negotiated settlement. Well, if your best alternative is business as usual, there's not much incentive. Secondly, and more fundamentally, Indigenous peoples holding inherent title and rights were not involved as governments in these planning processes. Rather, they were treated as one more stakeholder. And that seems very obvious to us now, but it wasn't at the time. And I remember a great quote from someone from Treaty 8, which was like, "We're not the Skidoo Club." And, I thought that captured it. So ultimately, back in the day when I was in grad school, I ended up focusing there and also in much of my early work in West Coast on tenure reform. At the time, I said for ecologically and socially responsible forest use in BC. So when I took over from Mark Haddock as West Coast forestry lawyer in the late 90s, some of you may know Mark most recently as general counsel for the Forest Practices Board. He had put in countless hours to shaping the new forest practices laws from the 1990s, including the Forest Practices Code, Biodiversity Guidebook, and so on. And one of my first roles as West Coast's new forestry lawyer was the editor of multiple editions of West Coast Guide to Forest Land Use Planning, which attempted to provide a plain language guide to how all these new forestry law pieces fit together and how residents could get involved. However, almost before it fully started, the watering down and the loopholes began to emerge from policy limiting new protection areas to 12% of the province coming out of land use planning, to limits on timber supply impacts permitted from landscape unit planning, which you may remember was meant to be the sort of core biodiversity planning. That was 4%. And measures for endangered species, that was capped at 1% of timber supply impact. And with that, we saw the politics and economic pressure from the industry really preventing what was then the new regime for forest practices, regulation, and planning from reaching its full potential, or in many cases, being fully implemented. So too quickly, with it, a change in administration in 2001, what we called at the time a new era of lawlessness began. And actually, I just had one other slide I was going to show you because this is funny. This was from this was from one of our posters at the time. We did we did a tour around the province with a number of allies, and rather than deregulation or removal of red tape, we went with the Western theme and on a new era of lawlessness. Just looking at the time here, I think we should be fine. I did want to Well, just to name that era, which was really a sort of a 2001 to 2017 period of time, we saw the end of consensus-based land use planning, new policy that plans would only be done if there was a business case to do so, the repeal of the Forest Practices Code, and its replacement with the so-called results-based approach and heavy reliance on professionals retained by industry. So despite the dropping of the floor of environmental regulation in the forest industry, I do feel that West Coast and our allies and clients made gains between 2001 and 2017. And I did want to say a quick word about a few of the approaches that West Coast supported during this period that allowed us to do so. So one was, really what was meant by that business case was that there needed to be enough financial and legal risk to catalyze a meaningful negotiation and planning process. Folks, I'm sure, are very familiar with the markets campaigns ran by a number of conservation organizations, essentially telling buyers in Europe and elsewhere, you don't want to buy BC forest products, they're unsustainably harvested. And the other source of leverage was, of course, created by court decisions. The Haida went all the way to the Supreme Court of Canada in a case involving a failure to consult over the replacement of a tree farm license, and had the Supreme Court of Canada saying, no, you can't do that without consultation. And so between that legal and financial risk, there were substantive outcomes negotiated, for example, in the Great Bear Rainforest. We worked on the Forest Stewardship Council certification standards, essentially giving those buyers a place to land. If you want to buy responsibly produced products, companies can voluntarily meet the standard. And through those various negotiations and agreements, there was pressure for some law reform. For example, I was very involved in negotiating the language of the new conservancy designation, which created space for protection areas that weren't sort of traditional parks at the behest of coastal First Nations. Secondly, as per usual, there are outside factors beyond what's going on in BC. And of course, during that time period, the softwood lumber dispute raised its head again. And I don't know how much it was on people's radar at the time, but there was significant pressure from some fairly important actors in the US arguing that privatization of BC forests was the only way to remove the so-called subsidy that our tenure holders had. And West Coast was a sort of a catalyst for and council for what we called at that time the Coalition for Sustainable Forest Solutions, which was West Coast and many conservation groups. It was also the communication, energy, and paper workers, where post-IWA, pre-steelworkers and Unifor, Forest Sector Union, the pulpmaker and woodworkers, the Unity BC Indian Chiefs, silvicultural workers, the BC Government and Service Employees Union. We built a very robust coalition, developed a platform for significant tenure reform and other measures, and essentially put it forward as an alternative policy pathway for, it was because it was the right thing for British Columbians. We also made the case that it would resolve some of the issues in the softwood lumber dispute we advocated for things like log markets as a way of creating a mechanism for timber pricing, et cetera. And we did prevent the privatization agenda, and we did secure a 20% take back in 10 years, which I think was significant. Some of that was used to move into BC timber sales to get, for those market price signals, but also there were allocations to community forests, woodlots, and of course to First Nations. And then finally, the third area that I wanted to touch on is that West Coast and my work in particular very much refocused on directly supporting First Nations who were implementing strategies grounded in their own Indigenous laws. And that, of course, runs the broad spectrum. My early work in that area was working with nations, for example, to do land use plans grounded in their own laws, to develop their own forestry codes. That work has expanded into many areas as well. And that eventually led in 2016 to the launch of our RELAW, or Revitalizing Indigenous Law for Land, Air, and Water program. And that RELAW is I think quite a unique legal support and co-learning program for nations who are researching, applying, and enforcing their own laws for environmental governance. Since 2017, there has been, at least in rhetoric, a sea change in many aspects of Crown Indigenous diplomatic relations. As we all know, there's the explicit commitments to Indigenous self-determination, to co-developing legislation, and that shift is best exemplified by the unanimous passing of the Declaration on the Rights of Indigenous Peoples Act in 2019 and its legal requirement to align laws with the UN Declaration, including the free, prior, and informed consent of Indigenous peoples. So these shifts, just in the last 6 or 7 years, in theory, do create pathways for Indigenous nations who've been developing contemporary expressions of their own laws to begin to see them respected on the ground and to sort of breathe life into a vision of legal pluralism, which looks not just to federal and provincial laws, but also to Indigenous law to guide us. And with Al Gorley and Gary Merkel's 2020 report from the province's Independent Old Growth Strategic Review, which, as you know, recommended prioritizing biodiversity and ecosystem health across all resource decision-making and legislating this priority. And with the commitment of the BC government to do so, I was feeling hopeful that a pathway to stewarding our forests within ecological limits seemed to finally be ahead of us. And I guess whether we choose to do so as a province will be an important issue for all of us to consider heading into the upcoming election and beyond. And regardless of what happens and what happens to those commitments, West Coast is going to continue to work to hold governments and industry accountable and continue our work to transform the legal landscape in ways that are more sustainable, more democratic, and more just. So those were my words. We covered a lot of ground. I think we have about 15 minutes to chat if people have questions or otherwise.